The accountability of the executive and public servants is a key syllabus dot point that certainly could come up in the WACE exam, but obviously we cannot guarantee that, but it's certainly a really good one to look at, given that it hasn't come up in the last couple of years. Important is that to make sure that you are very aware of the syllabus dot point that is underneath the accountability of the executive and public servants. So you're aware that if you get asked a question about collective and individual ministerial responsibility through Senate estimates and at least one other committee of the Commonwealth Parliament, through the Commonwealth Auditor General and the AAT, and finally judicial review, that you are referring to the accountability of the executive and public servants. Furthermore, be aware of the essential understandings of Unit 4 in terms of accountability and rights and the practices of governance. All those dot points about CMR and IMR, Senate estimates, etc., can all be linked to the key understandings of the rule of law, open government, and natural justice. As we know, the government must be accountable for administrative decisions and its political and legal power. And holding the executive government to account is a fundamental part of the rule of law and a defining characteristic of democracy and good government. So it's really through this balance of parliamentary and extra parliamentary ways of holding the cabinet, the ministry, and the public service answerable, responsible, and accountable that we are therefore able to hold the executive and public servants to account. By alone, each of those methods will not be able to fulfill completely the role of holding the executive and public servants to account, but in combination with each other, they can provide a very powerful mechanism for holding the executive and public servants to account. Just also be mindful that in terms of the accountability of the executive and public servants, they can be linked to the broader relevance of both Unit 3 and Unit 4. So you can see on the PowerPoint that you can link it to the roles and powers of the Prime Minister and Cabinet, to the roles and powers of the High Court of Australia. Remember, the High Court has limited executive overreach by preserving the Parliament's control over spending, for example, in the Williams and Commonwealth, or the colloquial term, the school chaplains case of 2012. There's also key essential terminology that could be reflected in a Part A short answer or source analysis question. And given that we know that the syllabus is quite brief at times, it can be broken up into the following of accountability, constitutional executive, political executive, and administrative executive. So when we look at accountability, we really need to be sure of being able to find that really clearly, whether or not it's in a Part A question or in a essay question. We need to refer to that word obviously in our introduction, and that needs to be defined. Executive power could also come up, that idea of the power to make laws and administer policies and programs. And as I mentioned before, in terms of the executive, it's divided up into the constitutional executive, the GG, which my learned colleague Alex Rosevere will talk about in the next session, the political executive, which is the Prime Minister, the Cabinet and ministers who make decisions and craft public policies, which is what I will be dealing with, as well as the administrative executive, which refers to the public service departments. We know that the real executive, which is the Prime Minister and Cabinet, is not mentioned in the Constitution and operates based on convention. And then that would be important to make note in our responses, particularly because that convention arises from the fundamental principle of responsible government. Okay, let's start with collective ministerial responsibility, which refers to a political convention that is part of the Westminster system of responsible government. This is a key element of responsible parliamentary government. The first element, remember, is that the governments are selected by Parliament and can be dismissed by Parliament if they no longer have majority parliamentary support. Again, we know that this does not occur, as on most occasions the government has a majority in the lower house. And this is going to that analysis of the dominance of the executive and partisan discipline. Hence, those motions of no confidence will be defeated by the government. Second of all, the idea of CMR can also be broken up into cabinet solidarity and cabinet secrecy. When we talk about cabinet solidarity, we're talking about the ministers are taking that joint responsibility for the decisions of cabinet. They abide by those decisions. They defend them in public, even if they did not agree with them. And this ensures that the government can be held accountable collectively for its decisions by the Parliament. It also works to maintain discipline and coherence within the senior ranks of the government. But in practice, what we have noticed is that many of the resignations in recent parliaments have taken place about disputes with the Prime Minister, I should say, as they could not support the returning leader as the newly elected leader. So not so much necessarily of not being able to support cabinet policy, but more because they could not support the leader. Secondly, the principle of cabinet confidentiality or secrecy, as that some of you will be aware of, requires that all those discussions, documents and decisions in cabinet are strictly confidential and can only be released publicly for a legislated period of time. This is a really important part of good governance, because it's with this confidence that ministers can enjoy freedom to explore all policy options without the need to temper their comments or views. I think this is really important in ensuring open debate and frank discussion, and keeps differences between those cabinet ministers hidden so they can present a united public face. However, the extent to which this is upheld, it can be undermined by cabinet leaks, as we are aware of. For example, in a joint parliamentary meeting, in the last part of Morrison's session in Parliament, he appealed to the coalition MPs to come together in the lead up to the election, because he wanted to emphasise this importance of unity of purpose. And one of those ways to ensure that emphasis on the unity of purposes was supporting the religious discrimination bill. But we know that this was obviously not shown when 5 moderate MPs defied Morrison's plea and crossed the floor to support amendments to put in place protections for LGBTQ students. Excuse me, this sparked a backlash from Conservative MPs and the Christian lobby, prompting Morrison to shelve the bill. Another link there to obviously the influence of pressure groups. Another point to make a note now is of IMR. This is the idea that ministers must not mislead or lie to Parliament. They should not be personally or politically corrupt. They should avoid any conflict of interest, not bring Parliament into disrepute. There are 4 elements to that part of IMR. Again, this could be a question they might ask you for 3 elements of IMR in a short answer question. You'd only need 3 of those 4. We've seen IMR and accountability being upheld with the former departure of the Deputy Leader of the Nationals, Bridget McKenzie, after receiving advice from the Prime Minister about her involvement through a conflict of interest with her sporting club. I guess even though IMR is not always upheld effectively and fully, there is an expectation that ministers must be honest and competent. And I think that through IMR, it does establish an expectation of ministerial conduct and behaviour. And with that pressure, knowing that there is an expectation that ministers be honest and competent, there is a pressure to modify their behaviour, which could also bring about a resignation of a minister. So even though it's not always fully upheld, there does establish an expectation of ministerial conduct and behaviour, which I think is very important. We know that propriety has been the major issue in most recent ministers actually residing from Parliament. And obviously, this has been at the discretion of the Prime Minister in terms of dismissing that minister, because they obviously try to tough out any adverse public reaction if the minister is too valuable. There also is a trend by ministers to avoid accountability by blaming the public service or top public service for mistakes. A conflict of interest does appear to cause a resignation when it is evident and given wide media coverage, as does the abuse of travel and other expenses. Susan Ley is a good example of that. And we also know that many ministers have been reappointed to positions in the ministry later by a new Prime Minister. And again, the 3 candidates that we'll talk about in a moment did step down and then were back in the cabinet. Here's a really good example of personal behaviour was Andrew Broad, who was Assistant Minister to the Deputy Prime Minister, who resigned after allegations about his behaviour in Hong Kong. This is a good example of you using for IMR, besides obviously Bridget McKenzie. We talked about obviously the weaknesses of the ability of IMR to be effectively enforced, and because we've seen the return to the front bench after a period of time of 3 individuals, Barnaby Joyce, Susan Ley and Bridget McKenzie. So I guess what we need to note there is that Westminster conventions are insufficient by themselves to hold modern Australian executives to account. So there is a further need to use other mechanisms within Parliament or outside to hold our executive to account. In terms of the public servants and accountability, our public servants are important. They deliver services and programs. They provide policy advice. They regulate legislation and manage government resources under the Public Service Act of 1999. But they're also required to uphold the Australian public service values. There is arguments for the accountability of the public service, and there is also arguments against the accountability of public servants. So it's important that we are aware of both sides of the argument, that we can definitely incorporate that into our analysis, particularly when we are looking at each of the aspects of the accountability of the executive and public service. So let's have a look at Senate Estimates Committee. This is another important way that we can hold our ministers and public servants to account. It is often suggested that the Senate has emerged as a house that keeps the executive accountable, and it's compensated for the weakness of the House of Representatives by evolving strong accountability measures. We know that the Senate Estimates Committee was set up to obviously look into government expenditure, but it has actually evolved to become greater than that in looking into the scrutiny of the executive and government accountability. It does meet 3 times a year. It can directly question public servants from the relevant agency as well as the responsible minister. It also, as I said before, is used to probe into issues of government policy, not just their expenditure plans. It does uphold an important part in ensuring the rule of law, but there are still several weaknesses. It can become partisan, can be a piece of political theatre. We know the ministers from the lower house cannot be called to appear in person. Some of those senators lack the experience or expertise to analyse and evaluate complex financial information. And as well, ministers can hide behind political rhetoric. Whilst Senate estimates can be probing and bring to light conflicts of interest and impropriety and other key issues, generally the government will stand by the minister, which it could be argued undermines transparency and accountability of the executive. So again, this is just to solidify your argument in terms of the analysis. Important part of the Senate Estimates Committee was also used in terms of the sports rorts affair. So if we're going to use the sports rorts affair, we can obviously look at it in terms of IMR, and then we can look at it through the prism of the sports rorts affair. It was revealed that when Philip Gaetjens, the Secretary of the Prime Minister and Cabinet, was preparing his report about the sports rorts affair, he was not aware of the 136 emails between the PM's office and Mackenzie's office, nor did he interview anyone in the PM's office. This led Senator Penny Wong to suggest that the government kept the investigation deliberately narrow so as to protect the Prime Minister and his office. So the Senate Estimates Committee can bring light to these matters, and now they're on public record for therefore that we can surely hold our executive to account through this mechanism. One other committee that you can look at is the Committee for the Scrutiny of Delegated Legislation. Obviously, delegated legislation is an important part of the executive operations, because not all legislation needs to be discussed in Parliament and go through those normal mechanisms, particularly because there's so many pieces of legislation that need to be dealt with. So this makes it more efficient and be able to respond more flexible, I should say, to the needs of the government. But because this is still part of the separation of powers, we need to ensure that Parliament still has oversight of subordinate legislation. So this committee can recommend the disallowance of subordinate legislation if it decides the executive does not need to make the law or has overstepped its role when making subordinate legislation. And it's these methods of scrutiny and disallowance which can hold the executive to account, particularly through times like COVID-19, where the government had to respond very quickly to matters. Another important element in terms of holding the executive and public servants to account is the Auditor General. Remember that Auditor General is a public officer. It's appointed by the government who conducts independent audits of government spending to ensure that those responsible for expending government money do so in accordance with legislation. We know that they do performance and financial audits as well as assurance reviews. To perform this role effectively, it requires independence from the executive. So we have an Auditor General Act, which does set out the main functions, as well as the Public Accounts and Audit Committee. This ensures that the Parliament has a role in the Auditor General's appointment, funding and work program. So we know that the Auditor General is recommended by the PM, is appointed by the GG, but he or she is an officer of the Parliament. So the Auditor General's primary relationship is with the Parliament through the Joint Committee of Public Accounts and Audit. So the Auditor General examines the rules and systems used by the public service and other government agencies. So this is an excellent mechanism ensuring that the bureaucratic machinery of public administration is held accountable. They are widely seen as apolitical, ensuring both the independence and impartiality, and they can really focus on those financial statement audits and performance audits. We know that when the Auditor General does implicate a minister in wrongdoing, we have other parliamentary mechanisms such as the Convention of IMR and Senate estimates hearings, which can come into play to hold the minister or public servant accountable, i.e. that's Senator Bridget McKenzie. But there are limitations to the role of the Auditor General. Remember, they are limited by the separation of powers as they are a statutory body and can be modified or abolished by a new statute. They are also limited because they don't have judicial powers. They can recommend action about disciplinary action, but they cannot exercise judicial power by making a judgment and imposing lawful penalties. A really great example to be able to use when in holding the executive and public service to accountable is the Leppington Triangle affair. In 2018, the Australian government purchased a large parcel of land for obviously a larger value of money. But what they did was the Department of Infrastructure valued this piece of land, or the Leppington Triangle land, 1/10 of the price it had paid 11 months earlier. The A&O actually referred the sale to police, who concluded in September that there was no evidence of criminal conduct. However, what's important about this is that you can see that the Auditor General grant here appeared actually before the Senate Finance and Public Administration and Estimates Committee in October. He had to answer questions about the government's purchase of this 12 hectares of land. It was there he was able to tell the Senate estimates. It was the first time in 20 years he'd actually referred a case directly to the Australian Federal Police. So I guess in combination, Auditor General and Senate estimates seek to identify inefficiencies and potential corruption within the public service, which is really important. The Administrative Appeals Tribunal, while might not sound like it's really important, it is when it comes to those administrative decisions made by ministers, public service and agencies. Remember, they have delegated authority to make decisions that affect the lives of our citizens. So the AAT reviews decisions about the merit of a decision and whether it was correctly based on law and government procedure. It also ensures openness and accountability in the part of government and improves the standard of government decision-making. It's an integral part of our government accountability, but again, together with other elements of the administrative law system and judicial review in the courts, it can provide a powerful check on the executive and public servants. However, there are some limitations to this. The Act or regulation must state that the decision can be reviewed by the AAT. So they don't have a general jurisdiction to review administrative decisions, only where it is obviously stated within the Act or regulation. Another part is that the tribunal has no power to consider the constitutional validity of laws or the legality of government decision-making. One of the criticism recently of the AAT is that many of the appointments to this independent tribunal that reviews government decisions has obviously been increased under the Morrison government through actually appointing people with similar ideological or political backgrounds to the government. And again, this is concerning in terms of undermining public confidence in the key part of this system, with concerns that jobs for mates. I guess that's something that we need to be mindful in terms of a criticism, but obviously a weakness of the AAT. Before I talked about that, when we look at examples, and you always, in this course, there are lots of examples to cover, it's important to be able to reuse our examples in a number of ways. So if we want to look at Bridget McKenzie in the sports at Rorts Affairs, I've tried to identify how we can do that. So if you want to look at Bridget McKenzie through IMR, through the Auditor General, the Senate estimates, and the Prime Minister, this is a really good way to reuse this example in several ways. Finally, let's look at judicial review. Judicial review is really important because they can review the constitutionality or legality of executive action. They do this by reviewing the administrative decisions made by the executive. But remember, they can only decide whether the administrative agencies has exceeded their statutory powers. They do not decide on whether the decision was correct or not. If the court finds that the decision was not in accordance with the law, then Section 75 of the Constitution allows the High Court and federal courts to issue a writ of mandamus requiring a government official to carry out or not a specific act obliged under law. And obviously that can be a formidable force for the accountability of the public service. They can also issue an injunction to government departments or agencies which prevent certain actions from occurring. I think the Bilowa family, that was a good example of that. The courts can also review the legality of decisions of cabinet ministers, for example, Alexander and Minister for Home Affairs and Anor. Now, Mr. Stephen King talked about this case in terms of accountability of Parliament. We can do this in terms of holding the minister to account, because it was not within their authority to act as a judicial body or a form of punishment. Again, there are always limitations of judicial review, but it's still a formidable force for the accountability of the public service. It is only in the extent that obviously it can only act if a case is brought before it. The parties to the case must have standing or be directly or closely affected by the issues. And again, there is also the cost of bringing the action. And we just talked about Alexander and Minister for Home Affairs and Anor. Another really good example is robo-debt scheme that obviously is just begun a royal commission into it. This is just a really good example where robo-debt can be used for judicial review. It can also be really greatly linked to the rule of law, to also natural justice principles and AAT. Again, just showing, that procedural fairness had not been granted to these particular individuals. So a really good example of that. Finally, I also just wanted to make note of Prime Minister, the former Prime Minister, Scott Morrison, in terms of open government. Whilst the Attorney General said that, what he'd done was obviously not illegal, what is important to note that because people were not aware of the appointment of the former Prime Minister to these 5 different ministerial portfolios, it was really impossible for Parliament and the public to hold Mr. Morrison to account for the proper administration of that department, because we're unable to identify the minister who's been appointed to administer those departments. So if we are to hold our ministers accountable, we must know who holds that ministerial rank and what portfolios they administer, if we want to ensure that the practices of open government are upheld fully. So I guess my key takeaways is that the government must be accountable for administrative decisions and holding the executive government to account. It is a fundamental part of the rule and a defining characteristic of democracy and good government. But again, it's through this balance of parliamentary and extra parliamentary ways of holding the cabinet, the ministry and the public service answerable, responsible and accountable, which can ensure that they are held accountable. Again, just a final note for something you might like to give to your teachers is here's an essay practice question. Evaluate the extent to which the Commonwealth Executive and public servants through and choose different elements of the syllabus, collective and IMR, and maybe compare that with the Senate estimates or the Auditor General or judicial review. So again, I don't think that they'll probably choose all elements of that for you to address in the WACE exam, because there's quite a number of points to cover, but you could take a few of them and evaluate the extent of each of those mechanisms against the other. Thank you for your time.